In 2019, a legal historian at Emory University named Dr. Evelyn Marsh was cataloging a donated estate collection, the private papers of a Georgia law family whose records had gone unclaimed for 60 years. The collection was unremarkable: deed transfers, estate settlements, correspondence between Thomas Warren and various colleagues, the kind of archive that gets processed in an afternoon. Box 14 was different. Inside, she found 11 handwritten manuscripts, legal arguments drafted in a careful, educated hand. The paper was older than anything else in the collection, brittle at the edges, the ink browned but precise. The reasoning inside them was extraordinary, structured, cited, coherent, the kind of legal writing that did not appear in Southern law offices until decades later. Dr. Marsh spent 3 weeks trying to determine who had written them. The official record of Thomas Warren's law practice, 1837 to 1856, lists exactly one attorney, Thomas Warren himself. The official record says Thomas Warren practiced law alone for 19 years. What we found in Box 14 tells a different story. The man who wrote those arguments was never listed on a single document. He held no license. He was never paid. Under the law of Georgia in 1847, the year the most sophisticated of those manuscripts was drafted, he was not classified as a person. He was classified as property. His name was Marcus, and this is the story of what he did and how long it took the world to find out.
This channel investigates the histories that were deliberately buried, cases where the record was sealed because the truth was too dangerous to acknowledge. Before we go further, hit subscribe. We release one deep investigation every week. Next week, we're releasing a case from Tennessee, 1863, an orphanage where the official death register listed causes of death that are medically impossible. That investigation is already complete. The only question is whether you'll be here when it drops. Drop a comment right now. What state are you from? Because what happened in Georgia may not be as far from your home as you think.
To understand what Marcus accomplished, you first have to understand what he was working with. Not tools, not resources, not freedom. A wall and time. Marcus arrived at the Warren household in 1837, purchased as a domestic servant when he was approximately 14 years old. Records from the Warren estate describe him as well-formed, capable, quiet. The plantation was located 12 miles outside Savannah, Georgia, a humid, flat country that smelled of river mud and pine resin. In summer, the air pressed down like wet cloth. In winter, frost arrived without warning and left the ground iron-hard by morning. Thomas Warren was a prominent attorney. His office occupied the east wing of the house, a room lined with bookshelves from floor to ceiling, a wide oak desk perpetually covered in papers, and a single large window that faced the garden. The air in that room was always slightly different from the rest of the house, cooler, drier, carrying the faint smell of ink and leather-bound volumes. Marcus was assigned to that room. He cleaned it. He maintained the fire. He brought Warren his evening tea. He was invisible in the way that the architecture of a Southern household required certain human beings to be invisible, present, necessary, and officially unacknowledged. The wall between the office and the adjoining service corridor was thin, older construction, pine boards that had dried and contracted over decades, leaving thin vertical gaps between them, not enough to see through, enough to hear. Marcus heard everything. He heard Warren prepare arguments. He heard clients describe their situations and Warren identify the statute that applied. He heard depositions, case reviews, appeals. He heard Warren talk through the logic of persuasion, how to structure a brief, what a judge was looking for, where an argument was vulnerable. He heard this for years before he understood it. And Marcus was, by every account we have recovered, a man of exceptional intelligence, not the mythologized natural genius that history assigns to extraordinary people to make their achievements easier to explain away. He was intelligent in a specific, disciplined way, a man who listened carefully, retained what he heard, and thought in structural patterns. A man who, if born in a different body in a different century, would have been called a legal mind. He did not learn to read in childhood. He was not allowed to. In Georgia in 1837, teaching an enslaved person to read was a criminal offense. He taught himself, slowly over years, using discarded documents from Warren's wastebasket, draft letters, old case summaries, pages torn from legal briefs that Warren discarded. He matched the sounds he had memorized from listening to the written words on those pages. It took him 3 years before he could read without assistance. He never told anyone he could read. That silence was the first act of legal strategy Marcus ever performed. He understood, even before he understood law formally, that knowledge revealed is knowledge vulnerable. By 1843, Marcus had been listening through that wall for 6 years. He understood the structure of a legal argument. He understood how precedent operated, how one court's decision could compel another. He understood what the word standing meant in a courtroom and what happened when a legal argument lacked it. He had heard Warren argue before judges in Savannah and Macon and Atlanta. He had heard Warren win and lose, and he had heard Warren analyze afterward exactly what had made the difference. In 1843, Marcus began writing, not for himself, not as a personal record. He wrote legal arguments for actual cases, cases he had heard Warren discuss with clients, cases involving the legal status of enslaved people in northern courts, cases that abolitionist lawyers in Boston and New York were fighting with inadequate tools. The question of how he knew about those northern cases is one Dr. Marsh spent months trying to answer. The answer came from a second document found in Box 14, a letter written in a different hand, addressed to someone identified only as M. The packets from New Haven arrive Fridays. I have been told the arguments are read with great attention. They ask only that the source be kept private. I will have paper for you next week. Destroy this after reading. The letter was unsigned. It was dated 1847. Over the following months, Dr. Marsh's research team identified the likely intermediary, a freed black man named James Coffey, who operated a small printing and stationery business on the eastern edge of Savannah. Coffey was known to maintain contact with northern abolitionist networks, a fact that local authorities were aware of but had not acted on, as Coffey was careful, literate, and useful to white merchants who did not examine his other activities closely. Marcus and Coffey had found each other. The precise circumstances are unknown. What is known is the mechanism. Marcus wrote the arguments on paper concealed inside linen delivered to the household. Coffey passed them without attribution to abolitionist legal networks. The arguments arrived in Boston and Philadelphia and New York as anonymous documents, the kind of contribution that networks assumed came from sympathetic white attorneys who could not safely attach their names. No one asked. This is the detail that Dr. Marsh found most striking and most damning. The northern lawyers who received those arguments did not ask where they came from. she said in a 2021 interview. Partly because asking was dangerous, but also, and this is the part I find difficult to say plainly, because they would not have believed the answer. But before we discuss what those arguments contained and what they accomplished, we need to go back to 1844, 3 years before the first argument was sent north. Because in 1844, Marcus heard something through that wall that changed the entire scope of what he was trying to do. Warren had a new client, a slaveholder from Chatham County, who was attempting to recover 3 enslaved people who had escaped to Pennsylvania. The legal complication: Pennsylvania had passed a personal liberty law that made such recovery difficult without specific documentation. The client wanted Warren to find a way around it. Warren spent 2 evenings working through the problem aloud, the way he often did when the law was difficult, talking through the argument as though the room itself were a judge. He identified the weakness in the personal liberty statutes. He found the procedural mechanism that would allow a federal claim to override state law. He drafted 3 pages of legal reasoning that, he told the client, would give any northern court serious pause. Marcus listened to all of it. Then he went home to his sleeping quarters in the darkness, and he wrote the counter-argument. He wrote the argument against Warren's position. He found the flaw in Warren's logic, a small one but real. He identified the case precedent that Warren had not cited because it weakened the slaveholder's position. He wrote for the first time not just a legal argument, but a legal strategy, a set of moves that, taken in sequence, would defeat Warren's attempt in court. That counter-argument became the template for the 7 manuscripts that would eventually be found in Box 14. Between 1847 and 1854, 7 of Marcus's arguments were transmitted north through James Coffey's network. Dr. Marsh's team spent 14 months tracing their use in actual court cases. The research required cross-referencing the language and reasoning in Marcus's manuscripts against published court records and the private correspondence of abolitionist lawyers. It was slow, painstaking work, the kind that requires reading thousands of pages of 19th century legal documents looking for a phrase, a structure, a line of reasoning that matches. They found 7 matches. 2 of them were cases that were won. The first was an 1849 case in Ohio, a freedom suit brought on behalf of a woman named Clara who had escaped from a Virginia plantation. The brief submitted by the abolitionist lawyer contained a 7-page section arguing that Clara had acquired legal personhood through extended, documented residence in a free state. The argument was sophisticated. It cited specific precedent. It anticipated the opposing counsel's response and preemptively addressed it. Clara was freed. Marcus never knew her name. He never knew the case existed. He wrote into the void, toward a justice he could not see and would not witness. The second winning case came in 1852 in Pennsylvania, a more complex proceeding involving not freedom, but testimony. The question before the court was whether the testimony of an enslaved person could be entered into the record of a civil proceeding. The answer, under most interpretations of the law, was no. The argument submitted by the plaintiff's attorney introduced a line of reasoning based on an 1839 maritime case from Massachusetts, an obscure precedent that almost no practicing attorney in the North would have known to cite. Marcus had heard Warren discuss that maritime case in 1844. He had filed it away. 8 years later, from a law office he would never legally enter, he deployed it. The testimony was admitted. The plaintiff won. Think about what just happened. A man who the law classified as property, who could not enter a courtroom as a witness, let alone as an attorney, cited an 1839 maritime case so precisely that it changed the outcome of a Pennsylvania proceeding in 1852. His work won 2 court cases. His name appears in none of them. He knew none of this. He wrote in darkness, by candlelight, in a sleeping quarter he was not permitted to leave without permission, and somewhere in a city he had never visited, in a courtroom he would never be allowed to enter, a judge rendered a verdict partly because of what Marcus had reasoned through in the dark. Just when we thought we'd seen it all, the story intensifies. If this is giving you chills, share this video with someone who loves dark history. Hit that like button and don't forget to subscribe. Let's discover together what happens next.
For 17 years, Marcus maintained the discipline of invisibility. He gave Warren no reason to look closely. He was present, he was efficient, he was quiet. If Warren noticed that the fire in his office always seemed to be at precisely the right temperature, or that the papers on his desk were always in the exact configuration he had left them, not disturbed, not read, simply maintained with unusual care, he attributed it to a good domestic servant. Warren was not a man who looked for what he did not expect to see. But in 1853, something changed. Warren received a letter from a colleague in Philadelphia, a fellow Southern attorney who had heard through legal circles that a series of unusually sophisticated abolitionist arguments had begun circulating in Northern courts. The colleague had been given a copy of one of them. He thought Warren might find it interesting. Warren read it on a Tuesday afternoon. Marcus was cleaning the adjacent room. Warren read it twice, then he sat very still for a long moment. Then he got up and walked to his bookshelf and pulled out a case volume from 1839. Marcus, through the wall, heard the specific page being turned to. He recognized the sound. He had heard Warren turn to that page once before, in 1844. He had known from the moment he wrote the Pennsylvania argument that this moment was possible. He had been ready for it since 1847. Here is what Dr. Marsh found in the estate papers from this period. Warren wrote a single line in his private correspondence log, not a letter, not a journal entry, just a note to himself, dated March 1853. It says, "Check who has access to the library shelf." 3 words, then a question mark. That's it. 1 line. He never wrote another. He never acted on it, at least not in any document we have recovered. But Marcus knew. We know he knew because of what happened next. In the spring of 1853, Marcus began changing his method. He stopped writing arguments that drew directly from Warren's library. He shifted his sourcing, reaching back to cases he had memorized years earlier, cases from Warren's oral arguments rather than his books, cases that could not be traced to a specific volume on a specific shelf. He was, in effect, covering his tracks, retroactively, across a body of work that had been sent north over 6 years. He was doing what a lawyer does when they realize opposing counsel has found a weakness. He was adjusting the argument. Warren never confronted him directly. Warren was not a man who would confront an enslaved domestic servant about suspected literacy. That would require acknowledging that Marcus was capable of something Warren found difficult to accept. But the atmosphere in the office changed. Dr. Marsh found evidence of this in Warren's correspondence from 1853 to 1855, small references to household arrangements being reviewed, a letter to a colleague in which he mentions considering a change of domestic staff without explanation. Marcus felt it too. He had spent 19 years learning to read rooms as precisely as he read legal documents. He knew what was coming. In the winter of 1855,
James Coffey disappeared from Savannah. No arrest, no documentation of his departure. He was simply gone, his shop closed, his home vacated. The local newspaper ran a 2-line notice. Nothing else survives. Marcus lost his only channel north. For approximately 14 months, he wrote nothing. We know this because Dr. Marsh found no manuscripts from this period among the Box 14 documents, only blank paper, carefully folded, stored inside a linen package that had never been sent. He was preparing to leave. In March of 1856, Marcus escaped. The Warren estate records note his absence in a single line: Marcus, domestic, absconded, March 14, 1856. A reward notice was filed with the Chatham County Sheriff's Office. There is no recovery. He was approximately 33 years old. What happened to him after 1856 is unknown. There is no record of Marcus appearing in Northern Census records, freed persons registers, or Freedmen's Bureau documentation after the Civil War. Either he lived under a different name, the most likely explanation given his demonstrated instinct for concealment, or he did not survive the escape. Dr. Marsh's team has not been able to determine which. He left behind 11 manuscripts in a linen packet inside the lining of a cedar chest. That chest was moved to a property in Augusta, Georgia, after Warren's death in 1871. It passed through 3 estate sales. In 1947, a private collector purchased it and found the manuscripts in the lining. He recognized their significance but could not identify their author. He donated them to a Savannah law firm along with the rest of the estate collection. They sat in a box for 60 years, until Box 14 arrived at Dr. Evelyn Marsh's cataloging table in 2019. Before we reach the final act and the moment that changed everything for Dr. Marsh, if this story is moving you, share it. History tried to bury this man. The least we can do is make sure as many people as possible know he existed. Hit subscribe and let's finish this together. Dr. Evelyn Marsh spent 19 months on the Marcus case. She is, by her own description, not a person given to emotional reactions to archival work. She has spent 30 years in legal history. She has processed documents relating to slavery, to institutional violence, to the systematic destruction of human beings by legal mechanisms. She is, in the language of her profession, a careful analyst. She gave one interview in 2022 to a legal history podcast. In it, she describes the moment she confirmed the identity of the author. It was not dramatic, it was a single matching phrase, a Latin legal citation, an unusual one, from a 12th century canon law text that had been referenced in a 1788 English Admiralty case. The phrase appeared in Marcus's manuscripts. It appeared in Warren's own handwriting in a letter Warren wrote to a colleague in 1842, describing a case he had been reviewing. The same phrase, the same citation. One had been written by a prominent Georgia attorney. One had been written by the man who cleaned his office. "I sat with that for a long time," Dr. Marsh said. "I want to be honest about what I felt. It wasn't just admiration, it was something closer to grief, because I kept thinking about what it cost him. Not physically, though it cost him that too. I kept thinking about what it costs a person to spend 19 years being brilliant inside a wall, to write arguments that won court cases and never be able to say, 'I did this,' to know that you changed something and never be permitted to take credit for it, and to know every single day that the man on the other side of that wall would have had you punished or sold if he had understood what you were doing. That is not just intelligence, that is a particular kind of courage that I don't think we have a proper word for." She paused for a long moment before continuing. "He was practicing law 20 years before the first black man was officially admitted to an American bar. Not informally, not approximately, practicing law, winning cases, and we didn't know his name until 2019. That says something about the record. It says something about who we decide to count." The heartbreak of this story is not the injustice, though the injustice is real and documented. The heartbreak is smaller than that. It is this: Marcus spent 19 years in a room he was not allowed to occupy. He spent those years building something extraordinary out of the only materials available to him: sound, memory, stolen paper, and time. He sent that work into the world without his name on it. 2 cases were won, lives were changed, and he left no record of whether he ever knew.
In 2022, Dr. Marsh published her findings in the Georgia Law Review. The article was titled "The Ghost in the Brief: Attribution, Authorship, and the Unacknowledged Origins of Abolitionist Legal Strategy." It identified Marcus, surname unknown, birth date approximate, fate unconfirmed, as the likely author of 7 legal arguments that influenced Northern court proceedings between 1847 and 1854. 2 of those cases were won. In one of those cases, a woman named Clara walked out of an Ohio courtroom as a free person. She never knew who had argued for her freedom. Neither did her lawyer. Neither did the judge who ruled in her favor. The legal historians who reviewed Dr. Marsh's findings called Marcus uniformly one of the most remarkable legal minds of the 19th century. They noted that his arguments anticipated reasoning that would not appear in published legal scholarship until the 1870s. They noted that he worked without access to a law library, without formal education, without the ability to consult other lawyers, without any mechanism for testing his arguments, except sending them north and waiting. One historian wrote, "If we are honest about what this man did, we have to reconsider who we think built American law." The Cedar Chest is currently held by the Special Collections Division of the Emory University School of Law. The 11 manuscripts are preserved in acid-free archival folders. They are not on public display. Thomas Warren's law office no longer stands. The Warren estate was demolished in 1914 to make way for a cotton warehouse. The warehouse burned in 1923. The wall Marcus listened through is gone. The arguments he wrote through it are not. If you had spent 19 years building something extraordinary, in secret, with no guarantee anyone would ever know, would you have kept going? Marcus did, every single day, for 19 years. Drop a comment below. What do you think happened to him after 1856? Because Dr. Marsh hasn't stopped looking. If this story matters to you, and I believe it should, share it. Hit the like button, subscribe so you don't miss what's coming next week. We're going to Tennessee, 1863, an orphanage, and a death register that contains causes of death that are medically impossible. That investigation is already complete. The only question is whether you will be here. He wrote in the dark. Somewhere a woman walked free.
Subscribe to the Sealed Files for more hidden histories they tried to erase. Hit the bell to uncover another story that history buried. Every week, a case the world forgot. Subscribe to make sure you don't miss it.